So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing it, I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands?
told you I was gonna put hands on you.
Nasir Brown. Are you Nasir Brown?
Everybody in the ring.
I'm
I
sorry.
think we were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the cop. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
Wasn't able to get them.
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt. Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is foreign age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say. Because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing it, I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are hands?
I told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay, put your hands on the wall, because you're not listening. Don't listen. I don't advise that.
Blaine Dunnigan. Good morning, sir. Are you Blaine Dunnigan? And will your client waive the formal reading of the indictment?
It will, Judge.
See, Mr. Dunnigan, in clause number 25, DCCR 0566, you're charged with the 3rd-degree felony offense of driving while intoxicated, 3rd or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016, and after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yes.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
I have no objection, Judge.
It's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
What about Felicia Freddy? Just go through the motion.
I mean,
I get pleased today and then reset it for sentencing.
yeah. So she's just.
Good morning. Are you Felicia Freddy? Speak up loud
Speak
and
up
clear
a
so
little.
I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddy, in cause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
Lee.
We got it reduced down, is my recollection. Judge.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a class A or B?
Eluding is typically B, isn't it?
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the
Mrs.
end.
Smith says B.
Plea papers. A. Of that motion, second. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually played to the lesser included. Lesser.
Any objection to that?
I don't mind the court amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good, thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges,
Now.
the motion alleges that you violated your probation. Count 1 alleges that you committed the offense. So 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go.
If you found this video informative, please like, subscribe, and turn on the bell icon so you never miss the latest courtroom hearings, legal updates, and case analysis.